Welcome to The Explainer. Today we're unpacking a truly complex, historically massive mass tort action that's unfolding right now in Scotland. We're going to take a clear, objective look at the source material to really understand the scientific context, the intricate legal mechanics, and the claimant eligibility criteria that are driving these massive proceedings. This is a fascinating intersection of consumer history, geology, and the law. So let's get right into it. On one hand, we're talking about a product that was a trusted staple in Scottish homes for over half a century. From 1965 all the way to 2023, talcum powder was marketed for babies and used daily by literally millions of women. It was universally perceived as gentle, pure, and completely safe. But today, that 60-year foundation of trust is facing a billion-pound legal challenge. Thousands of UK claimants are now alleging these products were actually contaminated with asbestos, which they claim caused specific severe cancers. And this has triggered a massive group litigation, including the very first distinctly Scottish group action raised in the Court of Session. Okay, let's dive into this. Here's our roadmap for today. 1. The billion-pound legal clash. 2. The geological and medical science. 3. Examining the factual dispute. 4. Scottish law and proceedings. 5. Eligibility and overcoming barriers. And finally, 6. Compensation and next steps. Starting with Section 1, the billion-pound legal clash and the shifting landscape of talc regulation and litigation. So, the commercial and regulatory landscape for talc has shifted dramatically over just the last few years. Think about it. In 2020, talc-based baby powder was entirely withdrawn from the US and Canada. By 2023, it was withdrawn from the UK and globally, and the manufacturer completely reformulated the product using cornstarch instead. Now, it's really important to note that the manufacturer cited commercial reasons for this withdrawal, specifically falling sales fueled by what they called misinformation. However, running right parallel to this commercial timeline is a scientific one. In July 2024, the International Agency for Research on Cancer, the ARC, officially reclassified talc as probably carcinogenic to humans. This global shift is really what sets the stage for the enormous legal actions we're seeing today. Moving on to Section 2, the geological and medical science. Understanding the origins of the contamination allegations. Now, what's really interesting about this is the geological cross-section right at the core of the case. If you look at how these minerals form, slicing right through the muted teal talc deposits, you frequently find intertwining burnt orange veins of asbestos. In nature, these two naturally occurring minerals form in very similar rock structures, often sitting right side by side. This geological proximity creates a straightforward three-step chain of events that forms the entire basis of the claimant's case. Step 1 is the mineral reality. Like we just said, they form together. Step 2 is the extraction risk. Because they're so close in the ground, pulling the talc out carries a real risk of cross-contamination. If the deposit isn't inherently clean or rigorously purified, microscopic asbestos fibers can end up in the mined talc. And that leads to Step 3, the medical consequence. Talc itself is soft, but asbestos is a strictly classified carcinogen. The core allegation is that when these microscopic fibers are inhaled or absorbed over years of daily use, they can lodge themselves in human tissue. And because asbestos is so highly durable, it remains in the body, allegedly causing long-latency cancers that might only show up decades later. Which brings us to Section 3, examining the factual dispute, claimant allegations versus manufacturer denials. Now, we really have to act as an objective referee here, because these allegations, they are fiercely contested. On one side, the claimants allege that talc-based powder sold between 1965 and 2023 contained asbestos fibers. They assert that long-term use directly caused specific cancers, and they point to internal documents they claim show the manufacturer knew about the contamination risk for decades, but failed to warn the public. On the exact opposite side, the manufacturers, Johnson & Johnson and Kenvue, issue absolute and staunch denials. They maintain their products were subjected to incredibly rigorous purity testing and never contained asbestos. They state firmly that scientific evidence does not establish any link between their talc products and cancer, and they completely reject the allegations of hidden risks, maintaining the product was always safe for consumer use. The factual dispute here is profound, and for now, entirely unresolved. All right, on to Section 4, Scottish law and proceedings. How mass claims are managed north of the border. So, the crucial point is that Scottish claimants aren't just an afterthought tacked on to an English lawsuit. They form a completely distinct legal class. If we compare the jurisdictions, England and Wales are currently managing nearly 2,000 initial claims under a group litigation order set for the High Court in London in June 2026, and are using English tort law. But up in Scotland, it's a totally different mechanism. This is the very first contaminated talc case brought under the Civil Litigation Act of 2018. It's managed through bespoke Scottish group proceedings in the Court of Session, which means completely distinct Scottish laws govern the limitation rules and the damages framework. These Scottish proceedings basically rest on three main legal pillars. First is the Consumer Protection Act of 1987, which imposes strict liability. This essentially means if a product lacks the safety people are generally entitled to expect, the producer is liable. The claimant doesn't actually have to prove active negligence. The second pillar is common law negligence, which addresses those specific allegations of corporate knowledge, asserting the manufacturer breached their duty of care. And third is the Damages Act of 2011, which is a vital piece of Scottish legislation that empowers families to claim compensation on behalf of loved ones who have tragically passed away. Section 5, Eligibility and Overcoming Barriers, Navigating the Matrix of a Viable Scottish Claim. To actually participate in this group action, a claimant has to fit within a very specific matrix. First, the exposure window requires roughly 5 or more years of regular talc use sometime between 1965 and 2023. Notice that the use doesn't need to be recent at all. Historical use absolutely counts. Next, they must have a specific diagnosis of a long latency cancer, ovarian, fallopian tube, primary peritoneal, or mesothelioma. The claimants are primarily women due to the ovarian cancer link and the way the product was marketed, but men with mesothelioma are fully eligible, and so are the executors of deceased family members. Finally, the evidence required isn't impossible to gather. It basically hinges on medical records establishing the diagnosis, paired with a detailed personal or family account of exactly how the product was used. And this brilliantly illustrates one of the most misunderstood parts of the law, the time limit. You might be sitting there thinking, well, if I used the powder in 1970, hasn't the time to sue expired years ago? The answer is actually no. Under Scottish law, the strict 3-year legal clock starts at the date of knowledge. For most people, that date is simply when they received their cancer diagnosis, because that's when they knew they had a significant injury. So, for example, a woman exposed in the 1970s who is diagnosed in 2024 is not 45 years out of time. Her 3-year legal clock literally just started ticking in 2024. The long latency period is a defining feature of the disease. It's not a legal defect in the claim. Now, let's bust a few common myths that often stop people from coming forward. The biggest one, I don't have receipts from 1980. Can I even still claim? Well, overruled. The legal system actually operates in the real world. Nobody kept a pharmacy receipt for baby powder from 4 decades ago, and frankly, solicitors do not expect you to. The evidence for these claims relies on consistent personal accounts, family recollections of household habits, and verified medical records. The lack of a receipt is absolutely not a barrier. Here's another one, highly sensitive but incredibly common. My relative has passed away. Is it too late, or is it maybe somehow disrespectful to bring a claim? Again, overruled. The Scottish Parliament designed the Damages Act of 2011 specifically for this harsh reality. Wrongful death inflicts terrible emotional and financial losses on the living relatives left behind. Pursuing a claim on behalf of a lost loved one is an entirely legitimate, legally enshrined response to that loss. It's not too late, and it is precisely what the law was built to address. Finally, Section 6, Compensation and Next Steps, what participants can expect. Let's move to and see how this builds. If successful, the law tries to quantify the unquantifiable through structured compensation. It visually balances 2 main areas: solatium, which is the Scottish legal term for pain, suffering, the intense medical treatments, and the loss of standard health. For severe cancers, these awards can be substantial. It also addresses hard economic losses, things like lost earnings or travel costs for treatment. And for fatal cases, family additions are awarded for grief, lost companionship, and lost financial support. But here's the catch. The legal machinery requires proactive registration. The most urgent next step for anyone meeting the exposure and diagnosis criteria is simply to check their eligibility while that Scottish 3-year legal clock allows. These checks are completely free, and they're conducted on a no-win, no-fee basis. Which leaves us with this final stark synthesis of the whole situation, the binary reality. People who register valid claims participate in whatever outcome the litigation produces. People who never come forward do not. This litigation concerns ordinary people, an ordinary household product, and incredibly severe allegations that, we always must remember, are strongly denied. But it forces us to ask a really profound question. When a 60-year foundation of consumer trust collides head-on with modern scientific reclassification and strict corporate accountability, how does society ultimately balance the scales of justice? It's a heavy question, And the Scottish courts are about to help provide the answer. Thank you so much for joining me for this explainer. Keep questioning and keep learning.